Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic today will be the destruction of residential landlords by the city of Los Angeles. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio. It is October 5th, 2024. And the song of the day was My Heart Will Go On. That was performed, of course, by Celine Dion. It was featured in the movie Titanic. And believe it or not, that movie was released December 19th, 1997. December 19th, 1997, 27 years ago, ladies and gentlemen. I have an important announcement before we start the show, and that is next Saturday is a religious holiday. So instead of canceling the show, I am moving it, ladies and gentlemen, to Sunday at 3 p.m. So I'm going to ask everybody to tune in. That's going to be October 13th as opposed to the 12th. And of course, we'll always be back on Saturday for the next week and thereafter. But please tune in this week from tomorrow, Sunday at 3 p.m., and we'll do the show on that date due to the religious holiday. The topic of the day, and that is the destruction of residential landlords by the city of Los Angeles. That's right, ladies and gentlemen. This is an all-out war against residential income property owners. There's no other way to describe it. So let's talk about it. Why do I say that? And the reason I say that, it started actually with the onset of COVID. COVID started back in March of 2020, and the city of Los Angeles immediately passed laws stating that no evictions based on non-payment of rent or additional persons occupying the property in violation of the rental agreement or bringing in a pet in violation of the rental agreement, there'd be a ban on that eviction. That ban spanned from January 1st, 2020 through January 31st, 2023. That was 35 months that you could not enforce your property rights. You could not enforce your contractual rights. Who could allow someone to walk into a retail store, take whatever merchandise they want, and then the city passes a law that says that you can't ask the person for the money for 35 months? Well, that's exactly the situation that landlords found themselves with regard to the laws passed by the city of Los Angeles. Now, don't forget, we did have a pandemic. No one's arguing that. And we're also not arguing the fact that there was a lot of financial upheaval. But that financial upheaval did not last for 35 months, ladies and gentlemen. It lasted for maybe a year, and everything seemed to go back except for the insane politicians that wanted to keep this COVID attack going and going and going. And I would say to you, I would submit to you that the tenants who claimed that they were financially impacted after the first year by COVID, I would state to you 95% of them were not telling the truth. They were just gaming the system so that landlords would not be able to ever collect their rent. Now, the politicians claimed that we're not telling you that you can't collect your rent. We're just telling you that your rent is deferred. It's deferred. You can always go after them. We're not saying that the debt doesn't exist. This was such a phony statement by our elected officials for the city of Los Angeles. It finally came so many years after COVID had been over that finally on February 1st, 2023, landlords could finally bring forth an eviction based on current rent, not back rent, current rent. So if a tenant finally, after 35 months, if a tenant didn't finally pay the rent for the month of February of 2023, you could then bring forth an eviction. You could also at that time bring forth an eviction based on extra people or unauthorized pets. However, what about that rent that was owed during that COVID period? When could you collect that? Well, any rent owed from March 1st, 2020 through September 30th, 2021 only became due on August 1st, 2023. So that meant that you had to wait 41 months before you could finally collect your rent. And if any rent was owed from October 1st, 2021 through January 31st, 2023, you could only collect that as of this year on February 1st, 2024, which is a total of 47 months. 47 months that we could not collect our rent. This was a plan by the city of Los Angeles, and we'll get to what their plan was. Now, was there any relief for landlords? Well, yes. During this time period, there was a few different rent relief programs that assisted landlords in collecting their rent. But I would say, and the statistics are clear, that less than 50% of the landlords in that situation ever collected a dime, less than 50% from the rent relief programs. Part of the reason why they didn't was it took two people. So if the landlord participated and the tenant didn't, then the application would be denied. Simple as that. The application would be denied. Many times landlords didn't do it quick enough. Well, if you didn't do it quick enough, then you were denied your right to collect this rent relief money, which was only instituted by the policies of the city, which were based on phony data that COVID still continued. Sometimes landlords didn't collect because the program ran out of funds. So it didn't matter that both sides participated. There were no funds left for the landlords. There are still right now pending rent relief programs, and they're pending because there's no money to fund them. And last but not least, I heard many cases from my clients where the rent relief money was approved. And guess what? They didn't send it to the landlord. They sent it to the tenant and requested the tenant give that money to their landlord within 15 days. Do you know how many tenants did that? Do you know how many? Maybe 10%. So all these tenants not only weren't paying rent for that 35-month period potentially, but now they're in a situation where they were taking money that should have gone to the landlord. Now, once this period opened up, and landlords were allowed to finally enforce their property rights, they do have choices. So what are the choices? They could bring forth an unlawful detainer. And we did bring forth an unlawful detainer in many situations. In that first phase, you had to serve a 15-day notice to pay rent or quit. In that second phase, that became effective February 1st, 2024, in that phase, we only needed to serve a 3-day notice. But it becomes even more insidious. You see, tenants were only allowed to withhold rent if they were claiming COVID. So we brought some cases where the tenants didn't pay the rent during that COVID period. And the tenant walked into court, and I understand that this is bizarro land, ladies and gentlemen. You have to be standing on your head to understand what I'm going to say now. And that is, the tenants would walk in and say, no, I didn't pay the rent because of COVID. I had plenty of money. I just didn't want to. Well, if the tenant admitted that in a court of law, you lost your eviction case. This is insane because you're only allowed to go after the tenants who withheld the rent because of COVID. But if the tenant claimed, no, had nothing to do with COVID, I had the money, I just don't like this landlord. Can you imagine walking into court and saying this? But we had this situation, and the landlord would lose their cases. So unlawful detainers trying to bring forth an unlawful detainer during this time period was worthless. Could you go to small claims court and sue them? Yes. In fact, for that first period, which was from March 2020 through September 2021, small claims jurisdictions were unlimited for that COVID period. Otherwise, currently it's 12,500. So you could go to small claims court and you could file an action. And even if the tenant owed you 50, 60, $70,000, like happened to so many of my clients, one tenant, 50, 60, $70,000, you could sue them. But in many cases, the tenants moved. Well, of course they moved, right? Of course they moved. So you file a small claims court action. And what's the next thing you got to do, ladies and gentlemen? The next thing you have to do is you have to serve them with the lawsuit. Well, do you think the tenant who owes you $50,000 is leaving a calling card as to where he's going to be? And the answer is, of course not. They're not going to do that. Okay, which means you're going to have to do some sort of skip tracing. Maybe you know where they work so you can serve them there. But otherwise, this is just lost rent. When the city council said, no, we're not saying that we're making landlords give up the rent, we're just deferring it. That was a bunch of hogwash, ladies and gentlemen. How many landlords lost thousands and thousands and thousands of dollars during this time period? But the plot thickens. You might have heard that from March of 2020 through February of 2024, there was something called inflation. In fact, it was terrible inflation during that period of time. Up to 9% one year, 10%. It's up to like 15%, 20%. Well, during this time period, the City Council of Los Angeles stated that you couldn't get a rent increase. No rent increases from March of 2020 through February of 2024. Did it cost you more to have a plumber come to your building? Did it cost you more for energy? If you were on a loan, did your loan rates go up? Everything about this period created more expenses for landlords who, by the way, weren't getting paid their rent. So finally, the city, as of February 1st, 2024, allowed a rent increase. 10%, 15%, 20%? No, they allowed a 4% rent increase. The first one in that time period, a 4% rent increase. And that extends, by the way, you can only do it once per year. We're talking about RSO properties, those properties subject to the rent stabilization. You can only do that up to, they're allowing that through March 30th, 2025. That's your rent increase. And you can do it once per year. So if you did it in February of 2024, you can do it again in February of 2025, but it's only 4%. So was the assault on landlords finally finished? Of course not. They instituted something called the fair market value. We've talked about this before. You cannot serve a 3-day notice on a tenant unless you are above the fair market value. So, for example, if you have a 1-bedroom apartment and the rent is $2,000, in order to serve a 3-day notice, the notice has to equal $2,081 for a 1-bedroom apartment and $2,625 for a 2-bedroom, $3,335 for a 3-bedroom, and $3,698 for a 4-bedroom, which means that in the example I gave, you'd have to wait another 30 days to even serve a 3-day notice. And in certain cases, such as Section 8, where you're only getting paid by the tenant a small amount, like $200, you'd have to wait almost a year to be able to serve a 3-day notice. This is highway theft from the city of Los Angeles against residential income property owners. Could it get worse? Of course. In the face of all this punishment being put upon landlords, this financial punishment being put upon landlords, the city said, you know what, we need to do something else. Let's start something called the Just Cause Ordinance. So if your property is not subject to RSO, let's pretend it was a newer building or a single family home, not subject to the rent stabilization ordinance, let's put a little more pain on the landlord. Under the Just Cause Ordinance, which applies to every single residential unit in the city of Los Angeles, except those that are under RSO, the Rent Stabilization Ordinance. So if you've got a single family home in Brentwood, you're under the Just Cause Ordinance. So what is the Just Cause Ordinance? Well, they can't regulate the rent, but they can tell you that you need good cause to evict. So let's pretend you have a single family home with a tenant in possession on a month-to-month tenancy, and you're planning on selling it. So you're giving the tenant a certain notice to move. Well, that's not good cause. Good cause is not that you want to sell your property, which means you're going to have to figure out another way to get rid of them. But a single family home, a townhouse, and a condominium, in those cases, you could just raise the rent. There is no limitation. But if you raise the rent, okay, that might have the effect of having the tenant vacate the unit. But then the city passed another law as part of this Just Cause Ordinance. And that is, if in fact the tenant decides that he doesn't want to pay the increase in rent, he can move. You're thinking to yourself, great, that's what I wanted. But then comes in another chart. It's called the Economic Displacement Relocation Assistance Chart. And on this chart, it states that if the tenant doesn't want to pay the rent increase, now you have to pay them relocation. This is totally illegal. It's already being challenged by one of the apartment owners associations. But it states in that, for example, a single family home, not too bad, you'd have to pay them 1 month's relocation. But if you've got yourself a 3-bedroom condominium, you raise the rent because you have the right to do it above 10%, then the tenant can choose to move and demand his relocation. For a 3-bedroom, it's $11,416. For a 2-bedroom, $9,286, and $76.54 for a 1-bedroom. This is if you're just merely raising the rent, which you have the right to do. By the way, don't forget, vote no on Proposition 33 and yes on Proposition 34. That will ruin our industry. Okay, so why is this a conspiracy against landlords, residential landlords? Why? Well, the first is easy. Elected politicians want to curry favor with tenants to hold on to their elected positions, regardless of the consequences to the industry. It doesn't matter. They know that there's much more tenants than there are landlords. So any law that they can curry favor with tenants, regardless of the concept of economics, which, by the way, only makes rent go up. Rent control only makes rent go up. All these situations where you're seeing it goes up because who in their right mind would want to build residential units in the city of Los Angeles and a lot of other municipalities, I might add? Who would want to do that? And the answer is no one. Well, less supply, more demand, the prices go up. New tenants moving into a vacant unit, you're paying more rent because you're subsidizing the tenant who's been there for 15 years and is paying way under market value. Now, the second part of their conspiracy was their intent to make landlords divest themselves of the property. Well, why would that help the city of Los Angeles? You're just going to get another landlord, another owner to own the property. Well, you see, the city passed something called the mansion tax. Remember that one? So if you sell your building worth $5 million, which is common for an apartment house or more, you're going to have to pay the city a tax, 4% of the sales price on property worth $5 million or more, and 5% on property worth $10 million or more. So the city, by creating these plans, are now in a situation where they're directly benefiting. So they get the benefit of currying favor with with tenants so that they can remain in power, and they also bring more money to the city coffers. And there's one last thing. Every time you sell a property, you know it's going to get reassessed. This will indirectly help the city of Los Angeles and, of course, the county of Los Angeles, because it's going to be assessed at a higher value, ladies and gentlemen. And being assessed at a higher value means that more property taxes, which will indirectly help the city of Los Angeles and, of course, directly help the county of Los Angeles. That, notwithstanding, is the end of my topic dealing with the destruction of residential income properties by the hand of the city of Los Angeles. I want to remind you once again that next week's show will be on Sunday, October 13th at 3 p.m., a special Sunday edition, ladies and gentlemen. And now we're going to open it up to questions. We all know the rules, and that is that if you want to talk to me, please electronically raise your hand if you're in the Zoom room. You understand that what you're hearing today is for informational purposes only and does not constitute legal advice. And last but not least, if you do have a case with my law firm, I do not want to discuss specific cases with this seminar. This Zoom and live meeting is based on general legal questions. And with that, ladies and gentlemen, I'm going to open it up to M. Brosur. I'm going to ask you to unmute yourself.
Hey, Dennis, can you hear me?
I can.
Sure can. Good to see you again. Thank you for everything you do for us. Quick question. I just raised the rent on a single family home to my tenant that has been there for 8 years. The challenge that I'm having with that tenant now is that not only did he bring his girlfriend, 3 new kids, and 4 dogs, I'm thinking of doing an eviction soon on where I'm going to take the property back because I'm going to say that me or my family, immediate family, is going to be moving into the property.
Would I let me ask first, what city are we talking about?
Sylmar, San Fernando Valley area.
Okay, and this is a single family home with only one house on the lot.
Yes, sir. Yes, sir.
Okay, well, you certainly have the right to move in close family members or yourself. The close family members constitute your grandparents, your parents, yourself, your spouse, or domestic partner, your children and your grandchildren. So those are the close family members that you can move into this single family residence.
Okay. So I wouldn't have, would I have any legal repercussion just because he's now has 3 kids, 4 dogs, and he might not want to move? Do you think
well, I mean, that might be a violation of the rental agreement, certainly as to the dogs.
Yes, sir.
Did the rental agreement provide for him to have 4 dogs?
Nope, not at all. But the rental agreement was done month to month 8 years ago.
I understand, but the rental agreement did not allow for dogs. That rental agreement is still valid. So instead of putting in a family member, you might want to consider starting an immediate eviction on the basis that they're violating the terms of their contract.
Oh, thank you so much. And you, once more thing, no on 33 and yes on 34. Is that what you said?
Yes, that is what I said.
Absolutely. We're on it. Thank you so much.
Take care. Okay, we are going to move on to NDCP. How are you? NDCP.
Yes, Dennis, can you hear me okay?
I can. How are you, sir?
Thank you. Yes, and that was really an eye-opener on the destruction of landlords. I don't know what's gotten into these people, but it certainly doesn't make sense. But it does, right? To them, dollars and cents.
Of course it does.
My Lord. Here's the situation, right? Single-family dwelling, owner-occupied, city of Los Angeles, non-RSO, non-AB 1482, okay? And I did some research, and it looks like under the Just Cause Ordinance, I have 3 paths to pursue for eviction. I can remove the house from the market at a no fault. I can do a nuisance at fault and a rent increase that has not been paid for months as a fault.
Well, the permanent removal is not one that would be reasonable for you to do. That means that you're going to have to never rent that property out for the next 10 years. Even if you sell the property, the new owner would still be responsible for not renting that out. So I don't think that's a proper one. If the tenant didn't pay the rent on a rent increase, then that's a simple case for eviction. We can immediately serve a 3-day notice and proceed forward with an eviction based on the fact that you served a proper rent increase, I presume, and that the tenant didn't pay it.
Right. Now, this so happened to be done in 2021. We did the rent increase.
Oh,
And
that's probably a little stale at this point, so I wouldn't want to go back and even think about that at this point in time. Since you
okay,
didn't enforce your rights for 3 to 4 years, I don't think that would be proper.
okay, so do a new one on
Yeah.
90-day notice, is it, for rent increase?
If you're going to go above 10%, the answer is yes, and you have to
Yeah,
allow 5 days for mailing. So if you were going to serve it, let's pretend now,
yeah,
October doesn't count. It would be November, December, January. It would take effect February 1st.
okay. And what about the nuisance
Well, you
path?
didn't describe what the nuisance is. What are they doing wrong?
It's extreme hoarding, just all over the bedroom, the family room, the
Okay, well,
restroom.
that's a violation of the contract. I wouldn't call it, it could be considered a nuisance, but it would be better to go on a violation of the contract because every contract says
Okay.
that you have to keep the premises neat and sanitary. Obviously, that's not.
Right,
So we would give them a 3-day notice to perform or quit, giving them 3 days to return the premises to a neat and sanitary condition. These people really have a sickness. They're not going to
yes.
do it and will be going forward with an eviction.
Right. And this
Go ahead.
individual, he likes to fight to stay wrong. So he's going to request a jury trial, so all these paths,
Well,
what,
we're not afraid of jury trials. We've won our last 5 jury trials in a row, so we're real good at it. Anyway, thank you very much. We are going to move on to Alex Rodriguez. How are you?
Hi, Dennis. Thank you for the incredible value you're providing.
My pleasure.
So, I have a question, which is I'm buying a duplex, I'm under contract, and before I get myself in more trouble, um, I'm going to be owner occupying it. It falls under the statewide rent control. So,
Okay.
there's two tenants. Well, it's a duplex, so side by side. They don't have any leases. I'm waiting for the stopples to make sure that they're month to month. Obviously, I can move in giving the 60-day notice. But my question is for the other side, is there any, once I'm there, being that there's no leases in place or the old owner never had leases, can I make it fall under AB 1482 or no?
Okay, well, I don't understand why it wouldn't be under 1482. So let's talk about this. What city is the property located in?
Sacramento.
Sacramento. I don't know whether Sacramento has their own rent control or not, but let's presume they don't. If this is a duplex and it's more than 15 years old, then you would be subject to AB 1482. So you can move in, you'd have to give them a relocation. Now, if the other tenant eventually moves out and you lease it to another person, as long as you were there first, then the property is not subject to AB 1482 at all. But
Okay.
right now, you'd be subject to a rent increase of 5% plus the CPI. I'm not sure what it is in Sacramento area, but you could raise the rent on that remaining tenant after you get the other one out.
But I wouldn't be able to increase it more than that, being that it is subject to that 1482, correct?
That is correct. Now you could, after you move in, you might tell that tenant that, and you have the right to renovate that unit. And that would be a ground to ask that tenant to move because you want to renovate the unit. To renovate the unit, it's work that would render the premises uninhabitable for 30 days and requires the obtaining of a building permit. So you get yourself a contractor, he pulls the permit, he gives you the quote scope of the work showing that it's going to take much longer than 30 days. And then you have the right to ask that tenant to move. You got to pay relocation. It's only 1 month's rent. It's not a
Yeah.
big deal. And since you're now already in the unit, when the next tenant comes in, one of the exceptions under AB 1482 is a duplex, which is occupied by the owner prior to the tenant entering the tenancy.
Okay, that's exactly my plan. I just wanted to be sure.
All right, good luck. Oh, by
Thank
the
you.
way, I think in December I'm coming to Sacramento, and I'm sure if people know me, they know why, and that is because the Lakers are playing the Sacramento Kings. So I'll be up there for that game.
Fantastic. Have fun.
All right, thank you. All right, moving along to Austin. How are you today? Mr. Austin. There you go. Say hello. Unless your mic is not working. You know what, Austin, I'm going to move along, but I'll get back to you. Figure out why your mic is not working. And we're going to move on to Diane D. How are you?
Hi, Dennis. How are you?
I am fine, thank you.
Good. Hey, Dennis, I have, excuse me, I have a cough. I have a problem rental that I've asked you a couple questions on, but now I think it's coming to a head. It's single family residence, city of LA, new rent that I had given a 90-day notice is due this month on the 1st at $27.50. And my tenants sent me a cashier's check, which is unusual for them, by certified mail, which is also unusual for them, for $1,100. So I'm thinking that there's some sort of formula in there that they're trying to play a game. Would
Well,
that be?
well, of course. You're saying you raised the rent, is that correct?
Yes, the rent was raised and given a proper 90-day notice.
Okay, so what you
Due.
want to do is you want to return it saying, I don't accept partial payments of rent, and we're going to then issue a 3-day notice to pay the rent.
Okay, I will do that.
Perfect.
Thank you.
Okay, good question. Okay, let's move on to, hopefully, Austin, you're getting it together, but I'm going to take Daniela first. How are you?
There we go. Hi, thanks, Dennis. Thanks for doing this. 4-unit, I have an apartment available, RSO in Los Angeles. So I have an applicant that provided me an African passport as an ID. She makes her money from the internet, which just perplexes me completely. And she's self-employed, provided 2 years business tax returns showing a 6-figure income, which sounds great. She has a 3-month checking account that doesn't show any deposits, just a beginning balance. Can I request another account where she keeps her money?
Yeah,
And
absolutely. You want to see, statements that show that where the money was coming in. If she's making 6 figures, I want to see where that money come in. There must be a bank statement to that effect.
there are some conflicting things on her credit. If she's making all this money, I don't understand why those issues are coming up.
Yeah,
So,
you have the right to reject applicant based on color. I'm going to repeat that. You have the right to reject an applicant based on color. But let me tell you what the color is. It's the color green for
green.
economic reasons, ladies and gentlemen. Don't get scared out there. Okay. So it's for economic reasons. This seems like that there's too many red flags on that, and you could easily reject the applicant on that basis.
Got it. Thank you.
Okay. Okay, so we're going to go back to Austin. Let's see if you figured it out, Austin.
Hey, Dennis, can you hear me?
I can. So what was wrong?
Oh, just another example of me trying to do this on Bluetooth in my car while driving, which is just not good.
Oh, I think you said that before, young sir.
Yeah, one of these days I'll learn.
That's okay. How can I help you today?
Well, thanks again for the invaluable advice. I got 2 simple questions. So I bought this 4-plex in the city of Long Beach a couple months ago, and when I was redoing the leases, the previous leases were all month to month, so I put them on 1-year contracts using AOA forms. And the one tenants were a family with 4 kids, They're all on the lease. However, the mom just would not give me their birthdays. She claimed that's too much information. You're not allowed to do this. And I said, that's not true. The lease that I'm showing you has been vetted by lawyers, blah, blah, blah. But then I said, you know what? I'm not going to hold up lease signing if you're not going to give me their birthdays. So I kind of caved. And I recently saw one of them at the property, and he most certainly looked over the age of 16. So what I want to do is I want to somehow find out if that individual is 18 and put him on the lease and then subsequently raise the rent accordingly. How should I do this?
Well, and the answer is simple. You can't. I don't know why you need to know you have some plan about knowing the ages of the kids. I do recommend that you do write the kids' names when you're originally leasing it to them and the birth dates of those kids. And you do that because you want to make sure it's the same occupants. But they're already in possession. You're just trying to get them to sign a new rental agreement. And there's no way, because an extra person moved in, that you're allowed to now raise the rent. That doesn't work in the city of Long Beach or under AB 1482. So it might work in the city of Los Angeles. But again, these are the original occupants. So it's not an extra person. This is the same person. And the fact that somebody gets to the age of 18 doesn't mean, oh, you're an adult now. Now I can charge. Doesn't work like that, Austin.
Okay, well, that's fair.
Be
But
happy that you got them to sign a lease. You don't need to know their dates.
Yeah. All right. The other quick question is, this tenant, I can already tell, is going to be one of those tenants that pays after the grace period. And towards the end of the contract, I would think probably maybe $800 in late fees are going to stack up. How likely am I going to be able to collect that in small claims?
I think you can collect it in small claims, but more importantly, if the tenant doesn't pay the rent timely, you can serve a notice to perform or quit to pay the late charge. And if you're using the AOA form, that is a proper late charge provision, and we can do an eviction on that. So if that's what you want to go to.
What I'd rather do is I'd rather just say, okay, I'm not going to sign you again for another term unless you pay the late fees.
But again,
then,
you don't have the option of not signing. They're protected tenants. If they didn't sign the rental agreement, there's nothing you can do about that. And when this lease expires, that just means they're on a month-to-month.
Right. Okay. Yeah. No. They signed it. So I was just thinking of different.
But you're saying if you don't pay my late charge, I'm not going to renew it. Well, you don't have a right not to renew it. It's going to be month-to-month at the end of the 1 year. I'm going to move on. Thank you very much. We're going to move on to a computer by the name of Dell 7010. I'm ask you to unmute yourself. And Mr. Dell, I see you have unmuted yourself, but I might be having a problem with the mic. Can you speak? I think you have a problem with your mic. So on that basis, I am going to leave you there. We'll see if we can get to you later. Lorena, going to ask you to say hello.
Hello.
You did
Can you
good.
hear me?
Yes.
Oh, yes. Dennis, thank you for all you do for all of us. I really appreciate it. My question is as follows. I am currently owner occupied. My son is living in a home we paid relocation costs for 1 month and the tenants left. My son is now moving into the home. My question to you is this. He is going to have a roommate. My son is obligated to live in the home for 2 years, which is no problem, but he's going to have a roommate. And so we want to make sure what are the roommate is renting a room and will use the bathroom, kitchen, and living room. And we'd like to know what kind of lease do they have any rights? What kind of a month-to-month lease can my son give to the roommate?
I think the standard rental agreement, like that I have on my website, is fine. When you list the address of the property, you're going to state the address and you're going to say, and the 1 bedroom. And you might want to also have an addendum where you have some rules, which you'd have to think of yourself, like cleaning up the dishes, not leaving your underwear in the middle of the living room, some house rules that you might want to add to it because they're living there with you. But you're fine with regard to using a standard rental agreement, just listed bedroom number one or however you want to describe it.
And can we do a month to month or
Yes, of course. Of course you can do a month to month. This is in what city, please?
City of Burbank?
Yeah, you can do a month to month, but your son doesn't own the property, right?
No, I own it, but we end up having to do owner occupied because of many problems with the previous tenant.
Right.
And so now he will live there for 2 years, but of course, my mortgage is really high, so he can't afford, the regular rent, and he needs a roommate. And so we just wanted to make sure that we're not violating any laws or anything by having the roommate and
No,
how
you're
much we
not.
can charge.
You're allowed to charge. You're fine on that in that situation. Okay.
Okay.
All right. Thank you very much.
Thank you, Dennis.
Okay. I see somebody in the chat, and it's hard for me to read the chats because I'm the engineer of this, is saying that they were having problems getting me between the 7 to 8 o'clock hour. I answer about 10 phone calls. I'm not sure why you're having a problem, but if you do want to reach me Monday through Friday, between 7 to 8, call the number, our main office number, is 1-800-77-EVICT. Soon as you hear the recording, punch my extension, which is 1001, and you'll get to talk to me personally Monday through Friday. Do not use that extension at 6:59. Do not use it at 8:04 because I will violently hang up the phone. So that was for, I think, Evelyn, who was asking me that question. Moving along to Jim Polina. Oh my God, you weren't first today.
Hi, Dennis.
I guess you were
Yeah.
sleeping in that ADU that you're just
Well, I'm
constructing.
visiting my daughter in Sacramento, so I got distracted.
Okay.
So you did answer a previous question I had, and so I'll kind of vary it a bit. On a late fee that's not being paid, you said issue a notice to cure or perform. Why not a notice to pay?
Well, unless the contract states that it's rent and it's not rent, a late fee is not rent.
But my contract does say it's rent.
Then you can do it. The problem with that is, well, your property's not in the city of Los Angeles or unincorporated areas of LA County. Then you have to get to that fair market value. So,
Oh.
but if it doesn't state that, then of course it's a notice to perform or quit. If it does state it, then technically you're supposed to serve a notice to pay rent or quit.
Okay, so my real question here is, you mentioned you collect rent by using a rent collection box. I think I heard you say that.
Yeah, one of my
What
buildings
is-
does have a rent collection box, correct?
Oh, one of your buildings, but in general, renters will, how do you collect rent from your renters normally? Do they pay the bank directly?
Normally, I have a management company and they take care of that. There's one building in Studio City that I have a rent collection box. And then of
I
course
get it. I get it.
the office buildings that I own, they just send in the rent to me.
Well, Dennis, that lecture you gave was fabulous. I would copyright that. I would broadcast that throughout the nation. I give it to the presidential candidates. That was very comprehensive. That was great.
Thank you very much. I'm so glad my law practice is not in the city of Los Angeles. And of course, I don't live in the city of Los Angeles. Anyway, thank you very much. We are going to move on to Bert. Bert, I'm going to ask you to unmute yourself.
Got it. Can you hear me?
I can. By the way, Dell, if you got it together, you're going to be the next one. But Bert, go ahead.
Okay. I'm a new member of your fan club. Thank you very much. I am an independent broker calling about a property that I own in Orange County, Fountain Valley. It's a condo. I had to put a initial lease, a 2-year lease, with an automatic built-in increase after year one. Right after year one, which is a couple weeks ago, the tenant claimed there wasn't enough storage and they just moved out. And I've got the 1 month security deposit, but I know I have an obligation to re-rent it as quickly as possible. But now the market rent is higher. Am I required to basically rent the property at the same or less to minimize that, or am I allowed to go to market, which I doubt? But I thought I'd ask you that.
That's a good question. Number one, you have 21 days from when he vacates to send that security deposit itemization, and you can put onto that form that you owe the rent for the remaining term of the lease. you might have a little extra notation, but if I do rent it out, then technically you will not be responsible for that term. The interesting question that you're raising is, hey, I want to rent it and I'm going to try to help this tenant minimize his losses by renting it to somebody else. But technically, if you try to rent it for more than what this tenant
The
is
500
paying,
pet, I'm sorry.
if you're trying to rent it for more than what this tenant was paying pursuant to the terms of his lease, then technically you cannot hold him responsible for the remaining term of the lease.
Okay, right. I won't, I have to think about that. The security deposit, part of that was a pet deposit. Does that go back to them no matter what because it's a pet, or can that be lumped together with the original security deposit?
Okay, well, first of all, in California, there is no such thing as a pet deposit. It's just
Okay.
a security deposit. So whatever you take, it's a security deposit. So in the future, please don't do that. You are entitled to usually a 1 month security and in some circumstances a 2 month security, but it's
Yeah.
only a security. It's not a last month's rent. It's not a pet deposit. It's not a refrigerator deposit. It's just a security deposit.
I see. Thank you, Dennis.
All right, you take care, Bert. Let's go now. Let's see if Dell 7010 has figured it out. Dell. Well, my good friend Dell, you're trying. My microphone has a problem. I charged the late fee and the rent. It's really difficult, my good friend, to read it from this. So you're going to have to either shoot me an email or call the office. I'm happy to answer it. Okay, Sophie, how are you?
Hi, Dennis.
Hello,
Thank you for
Sophie.
doing all this. Uh, this is amazing information. It really helps us a lot. I'm a past client, and I have a little situation here. I sent a notice to increase rent about 60 days ago, and my tenant, and I did send them a courtesy text saying I've sent you an increase that's going to be coming in soon. And immediately I got a text back saying we have mold.
Well,
So
one has nothing to do with the other, Sophie.
I know. I just went immediately out there and I looked at it. I took care of it also within a week.
Good.
Uh,
Excellent. That's what your
yeah.
job is.
The situation is that they did have a leak that was very obvious in the bathroom and they weren't notifying me about it. So it did get to the stage where it damaged the moldings and the wall, and it costed me way more than what it should have costed me because it was just a steel issue. Anyway, I've taken care of it. Now they're refusing to sign the rent increase. What
Okay,
are my
well, I have great news for you. Tenants don't sign rent increases. Okay. Tenants sign rental agreements. Okay. They don't sign rent increases. You just mail it to them. You got to give them an extra 5 days for mailing. In your case, were you raising it above 10%?
No.
Okay, so it should have just been a 30-day notice. So
30,
you're
yeah, I
fine.
gave them 60 days. So.
And you gave them 60. So if they don't pay at the end of the 60 days, then I have a special number for you. Are you ready?
Yes.
1-800-77-EVICT. And we'll take care of that for you.
Okay. And one more thing, I found out when I went out there to do a walkthrough as well. They have put this overground, huge 5,000
Gallon
swimming pool. Yeah.
Yeah, that's in violation of their rental agreement. They can't do alterations like that. So you can tell them to get rid of it. If they refuse, we could serve them with a 3-day notice to perform or quit, giving them 3 days to get rid of that pool. And if they don't, then you have the right to evict.
Yeah. Okay, sounds good. Thank you so much.
You have a good weekend. We are moving on to I got lost here. I don't know where Kendall went. Did I just got rid of Kendall? Maybe by mistake. No. Okay. Let's move on to, I see a phone here. that ends in 0497. I'm going to ask you to unmute yourself. You might have to hit *6 to unmute yourself.
Good afternoon.
Hey, how are you?
Lovely. By the way, I got an email today. I know you talked about this subject in the past regarding balcony inspections. Apparently Newsom extended it, so the deadline is now 2026, just for your information. And it was laden with a lot of other information. Apparently there's a lot going on the state level. At any rate.
I haven't heard that yet. Unless he just passed that, because it was supposed to take effect as of January 1st, 2025, but I'm glad that he extended it.
Yeah, that's California Apartment Association. They're pumping out a bunch of stocks. It seems like there's a beehive of activity. At any rate, my question is, in terms of emotional support animals, I get the whole thing. You got to have a therapeutic, pre-existing therapeutic relationship with a medical practitioner. Now, we have tenants that submitted us a letter, but it seems bogus. I mean, I would think the letterhead would seem more professional coming from an authentic doctor's office, but it looks like they just did an image search, right-clicked the image, and put it in a Word doc. So my question is, can we peel deeper to contact the medical office and say, well, hey, is this an original document from your office, or is this forged?
You certainly can do your investigation by calling the doctor's office to say, hey, did you write this letter? And they will tell you whether they did or they didn't. So definitely I would contact them. We do understand the rules that it has to be done by a medical professional, somebody that has a California license, that they have to have treated the person 30 days prior to issuing this emotional support letter, which has to indicate that the person has some disability and would benefit by having an emotional support animal present. So, but if you don't believe that that's a genuine, you can certainly make some inquiries. There's nothing wrong with that, sir.
So not invasive, not prying into, personal stuff.
No, you're just asking for the authenticity of the letter. That's it. Simple as that.
Okay.
Okay,
all right.
we are going to move
out.
on. Thank you very much. And we're going to go back to Kendall, since I think I took you out of order there. Kendall, are you there?
Yes, thank you.
Sorry that I must have hit the wrong button.
I don't know. No problem. I don't know what happened. But I thank you for taking my question. So, we have a single family home in Los Angeles that we have a 1-year lease on. It ends at the end of this month, and the tenant is currently 2 months behind in rent. And my understanding of the lease is that it doesn't automatically go to month. It requires an agreement to go to month.
Well, that's not true. By operation of law, when a lease expires, it becomes a month-to-month tenancy.
And you can't contract around that, because there's a provision in the lease that says it doesn't go to month at the end of the.
First of all, what city?
Los Angeles.
Okay, so you can't. It's as simple as that. Los Angeles has that just cause ordinance, okay? And under that just cause ordinance, you can't just say the lease is over, get out. You can do that if the lease was less than 6 months. But if you have a 1-year lease, you're beyond the 6 months. So you're just stuck with that.
Okay.
But a lot of people, so here's what I think you're thinking, but you're not expressing it. Tell me if I'm wrong. You're thinking, hey, the guy owes me 2 months rent, but the lease is going to be over the end of October. So you know what? I'm just going to wait till the end of October. The lease is over and he has to get out. If that's what you're thinking, that's fallacious thinking. If the lease says you have to pay your rent on time every month, what makes you think, if he's not listening to that term of the lease, that he's going to listen to the term of the lease that says I got to get out at the end of the lease? It makes no sense. So you got a tenant who owes you rent. He already owes you 2 months rent. I got an idea. And that is, you need to serve a 3-day notice to pay rent or quit. I don't recommend landlords doing it themselves because if you did, and all this stuff is on my website, you'd have to serve a proper form. That's on my website. You have to upload it to the city. The information's there. You have to have certain notices posted on the property. You have to have the bedroom count. They make it impossible for landlords to correctly do this. So on that basis, I suggest that contact my office, or if you're brave of heart, you can try doing it yourself. But I certainly wouldn't wait to the end of the lease. That does nothing for you, young lady.
All right. Thank you very much.
All right. Moving along to Arlene. Please unmute yourself.
Hi, Dennis. How are you?
I am good, thank you.
Good. Thanks so much for doing this as always. Just a real quick question. I'm sitting and calculating out the interest for the security deposit interest on my LARSO unit. It's 0.52% this year, but I have a tenant who's been in for less than 12 months. They're not entitled to that. Is that correct?
No, it's on the anniversary. By the way, the city of Los Angeles requires for RSO units that you pay yearly the interest on security deposits. You want to just go out of your mind, ladies and gentlemen. So if you haven't done it, I would certainly do it now. It's not going to amount to much, like $20 or something, even if they've been there for years. Because if you don't do it, that's a common ploy that tenants' attorneys are using to defeat non-payment of rent cases by claiming that the landlord didn't serve or didn't send the interest on security deposits. If you go to my website, evict123.com, and there's gray buttons there. One of them is legal issues. If you click on the legal issues, I actually have a chart for each year going back to, I don't know, 1980, as to what was the interest that was supposed to be paid each year. So add that all up and send your tenant a check if you have RSO properties for the city of Los Angeles.
Thanks, Shana Tova.
Thank you. And moving along to Pauline Chung, please say hello.
Hello, can you hear me?
I can.
Okay, thank you. Actually, I want to ask you is I have the contract with the tenant and they have a late fee for $10 each day. And the tenant was late for 2 months. So he paid like over like 300 to us. So is it legal on all this?
And the answer is it's tremendously illegal. You can't have a $10 a day late charge. If you want, check out my rental agreement.
Mm-hmm.
That's on the website, evict123.com. You go into the free form section, you'll see the lease. Check out my provision. That is going to not be held legal under any circumstances.
So even though give my contract saying okay.
Well, the contract could also say, for example, that it's legal to commit a murder. Your contract could say that, but we know that the law is above your contract.
Okay. So even though my contract saying charge them 200 is still illegal.
You got it.
Okay. I got it.
Thank you. Moving along. We've got one last caller. We're going to take Al. I'm going to ask you to unmute yourself, please. Al. Mr. Al. Okay. Let's go to Alexander Valentin. I'm going to ask you to unmute yourself. Okay.
Dennis,
yes.
I didn't have any questions. I'm sorry. I don't think I raised my hand.
Oh, okay. No problem. Your hand was.
But anyways, hello.
Nice talking with you. Okay, let's move on to Sonia. I'm going to ask you to unmute yourself.
Yes, Dennis.
Yes.
Hi, thank you so much. So quick question. My question has to do with if we wanted to issue a tenant a warning notice, kind of before issuing the formal
warning for what, young lady?
For making for noise. Nuisance.
Okay, that's a reasonable one. Hey, you're bothering other tenants. Please shut up, or I'm going to have to get that mean, ugly attorney Dennis Block on your tush.
Yes, exactly. So, what is that something that we would just draw up. I
Yeah,
think
and it's nothing
grade.
formal. It's just a letter saying, hey, I'm getting complaints. You're playing your music to 2 a.m. in the morning. People got to sleep. I'm getting complaints. This is a friendly warning notice. Stop it. Because if you don't, I'm going to bring forth an eviction.
Oh, okay, got it. Okay, thank you so much.
You're very kind. All right, ladies and gentlemen, we have made it through another week of Zoom Landlord Tenant Talk Radio. Once again, I want to remind you, special Sunday edition next week will be the 13th. Please, at least for the Zoom people, come in because I do want to have a full show with questions. Again, it's going to be Sunday at 3 p.m. I want everybody to have a wonderful weekend. And with that, I'm going to sign off. Thank you very much.